provided solely for informational purposes only. The information should not be relied upon as a substitute for legal, accounting, tax, or other professional advice. So you should contact your employment attorney for legal advice. As always, we have our resources, and two of our employment attorneys are listed here that help me with providing material for this. But the source material for this webinar comes from the California Employer Update, which is a monthly update from HR California, a SHRM email update, Think HR if it has labor law updates and compliance updates monthly, and also Karen Gabler at Like Gabler and Sherry Shavit at Tharp and Howell. So the agenda today, we're going to talk a little bit about Dynamex and some latest developments in Dynamex. We're going to talk about EEO-1 reporting requirements, no match letters from the Social Security Administration, some new posters that go out, the Crown Act, which was passed and signed by the governor in the last month, other revisions to required notices and brochures, and some later developments in court cases that might affect employers. And then also talking a little bit at the end about sexual harassment prevention training, which is required by all companies of 5 or more employees before the end of the year. And 5 or more, it doesn't mean you have to have 5 employees. You can have 3 employees and 2 owners, but that would reach 5 and you'd have to do that. So let's start out with Dynamex. Dynamex decision was a court case last year, which basically said that independent contractors are going to go under a new standard in California called the ABC test, which we'll talk about in a second. But the Ninth Circuit Court of Appeals just had a court case involving JanPro, which is a janitorial franchisee and an individual that worked for them. And the individual that worked for them, probably cleaning buildings, and their lawyer wanted to go to court and sue the employer over something that happened prior to the Dynamex decision. And the Ninth Circuit Court of Appeals said that was fine. Now, what that really means, we're going to cover the Dynamex decision here, and then we'll talk about how that might affect employers. So the ABC test is now the standard test. So a worker is only an independent contractor if they meet all 3 of these requirements. The first is that the worker is free from control and direction of the employer in connection with the performance of the work. And they perform the work outside the usual course of the hiring entity, and the worker is customarily engaged in an independently established trade, occupation, and business. And all 3 have to be met to consider them an independent contractor, which narrows the definition dramatically. So for example, up until recently, I had an independent contractor who was doing my accounting and bookkeeping. He basically took his own hours. He basically took care of the bank deposits and took care of everything to do with the bank statements and the paying of the bills and all that. It's not the normal usual course of what we do here. And he has an independently established trade. He has other clients he does bookkeeping and accounting for. He also does tax returns for 150 people, and he's got a business. So it met all 3 tests, and therefore he could be an independent contractor. Going to the next slide, the court has placed the burden of proof on the hiring entity to prove that each of those 3 factors are met in the ABC test. So the employer has to prove that that they meet all 3 requirements. The failure of any one of those requirements would make a 1099 independent contractor an employee. So the best advice that employment attorneys are providing is, if you're not sure how to classify someone, make them an employee. By the way, we had a 45-minute webinar about the Dynamex decision earlier in the year. And if you'd like a copy of it, just email me when you get your link of this webinar, since we're recording it, and I'll send you a link for that. So an independent contractor, the worker, again, has to be free from control and direction, perform work that's outside the usual course of a hiring entity, and customarily has their own independently established trade. If it doesn't meet all three, they're an employee. And I'll give you a couple of examples of what we've seen recently that cause issues in this area. One of my people was talking to an architectural firm. They have 9 architects. The architects only work for this one architectural firm. They do the architectural work that the owner of the firm wants them to do. They don't have any other business except for this business with this architectural firm, but he's classifying all of them as 1099 employees, with 1099 independent contractors, which according to Dynamex would not work. We have another case of a barber shop in the San Fernando Valley, but everybody was an independent contractor, but they only did work in that shop. They only did work for that employer or the guy that owned the shop, and that they're really not independent contractors any longer. So having said that, let's talk about what's going on in the state assembly right now. The state assembly on May 29th passed a bill called AB5. And AB5 basically is a law that codifies in law the Dynamex decision. So the Dynamex decision is a court case, Supreme Court of California. It was upheld by the Ninth Circuit, and now the Ninth Circuit says it can be done retroactively. But these people, these employer groups or these independent contractors, they are trying, the employers of them are trying to get them to be exempted from the bill. Doctors and dentists, lawyers, architects, insurance agents, accountants, engineers, financial advisors. So as an example with financial advisors, the Dynamex recording that I did, it's on YouTube. Somebody in San Diego who manages an office for Merrill Lynch saw it, watched the whole webinar, called me up and said, hey, I'm an independent contractor and I manage these 5 people, but we only work for Merrill Lynch and we're financial advisors, but I think based on the Dynamex decision, I should be an employee. And I said to ask a few questions of her, and I said, yeah, I think you're right. And this person called a labor attorney who only represents employees to sue the employer. Well, in the AB5 that was passed on May 29th, financial advising firms are trying to get themselves exempted, as are real estate firms. If you have a real estate office, whether it be a Coldwell Banker or a Berkshire Hathaway or what have you, most of the real estate agents were independent contractors. And they just use those offices and those computers and everything that the franchise offers them, but they were still independent contractors, and the law would cause that to be a problem. I also talked to a tutoring company a few months ago that has 25, 30 tutors that go and tutor mathematics and science and AP tutoring for high school students trying to get into college and things of that nature. And his employees always were independent contractors, but under the law, since they only do tutoring for his company, they don't have their independent businesses, and he tells them who to tutor and what hours and all that, they would be considered an employee under the new law. The other companies that are having a lot of problems with this are home health care providers. So people that do home health care, they're usually historically been independent contractors. Now, the Ninth Circuit had this ruling regarding retroactive, and it defies my logic in my mind as to what that means. But it basically says that even if you follow the rule for the last several years before the Dynamex decision, and it was the Borrello decision, and people had to follow that rule for independent contractors. Even if you followed that rule and you did everything properly, because of Dynamex, somebody can go back prior to Dynamex and sue you. Now, obviously, anybody can sue anybody in the state of California, and the issue really becomes that as an employer, your labor attorney is going to say to the plaintiffs and to the court, hey, you can't apply Dynamex retroactively because we were following the rules at that time, and now you're telling me that something that happened 2 or 3 years ago you can sue me for. That doesn't really make logical sense. So it hasn't been tested in court yet, but the Ninth Circuit did have that ruling, and it may be a problem. So moving on, EEO-1 reporting. this has been a hit and miss for the last year. Component number 1 was due May 31st, and that's typical of EEO-1 reporting. You have to report gender, race, ethnicity if you're required to do EEO-1 reporting, which is you have over 50 employees and you're doing work for the federal government, either as a contractor or a subcontractor, and other nonprofits that get government work, government funding in schools and what have you. There's a whole bunch of EEO-1 reporting requirements. But this year, you have to now report hours and pay data. And you have to do that for 2017 and 2018. And it's got to be done by September 30th. So that's something to be, it's a new requirement. First, we had to do the pay data, then they took it out. Then they said you have to do it again. And, you know, there's been a current ruling that says, yeah, you got to do that by September 30th. So be aware of that. Does your company have to fill out the form? I already talked about. If you have at least 100 employees, you have to fill it out also, or 50 employees with government contracts or subcontracts. And here's a website that will take you to this is a link rather to the website. Will take you to the government agency so you can input your information. As always, we're recording the webinar. We'll send it out in a PowerPoint to you, as well as the YouTube. So if you can either copy this website now or just go to the eeoc.gov and talk about EEO-1 reporting, and you'll be able to get the link. The website went live July 15th, which is just about a week ago. So you now can do the reporting. The Social Security Administration has resumed sending out no-match letters as of March to employers. A no-match letter is a letter that basically says the information you submitted in your payroll data and your payroll taxes and everything to Social Security, that an employee's Social Security number does not match with that employee name. It informs employers that W-2 forms do not match those records. It doesn't imply that the employee intentionally reported incorrect information. It could be a transposition in a social number. It could be somebody using a married name rather than a non-married, a maiden name or prior name, and they haven't changed the Social Security card. It could be that somebody is using somebody else's and it's identity theft. So California law protects employees who update personal information and protects them from being terminated if you get a no-match letter. So if you get a no-match letter, and we've had 3 clients already that have no-match letters, if you get a no-match letter, you have to provide the employee a certain amount of time to correct the error. So the cause of mismatched letters could be, you know, falsification, identity theft, what have you, or it could be because of a marriage or divorce. It could be that the employer transposed the number of the social number when they were doing inputting. But one way to avoid that, obviously, is to use E-Verify. E-Verify is an online system with the federal government where you can verify your Social Security numbers and everything prior to getting too involved with the employee once you hire them, meaning in the first couple days or prior to, well, when they provide their documents on their I-9 form. However, if you have a no-match letter, you should check your records for clerical error. That does happen. You have to notify the employee that you have a no-match letter, assuming it wasn't a clerical error. You have to ask the employee to confirm their exact name and their Social Security number. You have to give them a reasonable amount of time to resolve the mismatch, which I have read 3 different employment law opinions about this, but it seems 60 to 90 days seems to be a reasonable amount of time. The government says 30 to 90 days, but I would give them 60 to 90 days to have a reasonable amount of time. Ask the employee to contact Social Security Administration to resolve the issue, notify you once it's resolved. Once it's resolved, if the number was wrong or if there's a new W-2 they can fill out, it's called a W-2C form, which would have a necessary correction. If the employee can't resolve it, then my suggestion is you consult legal counsel so that you do the right thing and you don't get yourself in trouble by letting somebody go or firing them without talking to legal counsel. Practical example, I have a daughter, I have 5 kids. My middle daughter was going to work out of college for a company called Viacom, which is a large entertainment company. And after she submitted her social security number, she was told that there was a match problem. And somebody had taken her social security number and was using it in another state. And so she had to fill out a whole bunch of documentation for Social Security, get it fixed. And then because of that mismatch or that problem, she had to file her tax returns by paper for a number of years, because every time she went online to do it electronically, it came up with somebody else's name. So this happens a lot we see this a lot in restaurants. We have a restaurant company with 150 employees, and they seem to get 1 or 2 no-match letters every year. We have a couple other restaurants that get them, but it's just something to be aware of and how you handle it. New Parental Leave Act posting. So the old family care, the old CFRA leave and the pregnancy disability leave used to have 2 different notices. It's been replaced starting April 1st by this notice called the Family Care and Medical Leave and Pregnancy Disability Leave Notice, which is kind of a long name for a notice, but this is a new notice that has to be posted. If you get posters automatically every year, new state of California and federal posters, and you sign up for automatic updates, you would have already received this. If you don't sign up for automatic updates, then you're going to have to find the poster and you need to post it. Now, our company, we get our posters through Cal Chamber. I always ask for automatic updates. This is July, but there's already been since April 1st, when this came out, there's been 2 poster requirement updates since January. So we've received 2 updated posters, which we've posted properly. But if for some reason you didn't sign up for updated posters, you need to get this notice. The other thing about the poster notices, and this is just in general, it has to be in a readily available place in your company. Usually that would be where a time clock was or where a lunchroom is, but it's got to also be available for job applicants, which I was unaware of until last year. The job applicants also need to see that poster. And so our posters in the lunchroom, so whenever we have a job applicant here, I just take them on a little tour and make sure I show them the lunchroom and the poster if it's up on the wall, or the posters that are up on the wall. So be aware that's a new poster requirement. The new Parental Leave Act is new this year. It provides 12 weeks of unpaid leave, job protected leave, to bond with a newborn, foster, or adopted child. And that's something that's new this year. I will tell you that if you're in the city of Los Angeles, you need to be aware of something that's happening in the city council right now. I met about 3 weeks ago with 2 city councilmen, David Ryu and Nura Martinez, who want to pass a law in the city of LA that forces the employer to provide 18 weeks of paid leave for parental bonding. So be aware that if you're in the city of LA, we'll keep you posted on this, but the city of LA, 2 city councilmen are looking to put this new rule into effect, which would really be devastating for smaller companies that, number one, if somebody's out on parental leave, you're going to have to replace them or have somebody work overtime. So it costs you extra money. And then you have to hold their job open. And now the city of LA is saying, well, maybe we're going to have you also give them paid leave. So SB 188 was just passed. It's commonly referred to as the Crown Act, which stands for Create a Respectful and Open Workplace for Natural Hair Act. I guess since I'm bald and I have a hair issue, that this would apply to me too, but it's really to protect employees who wear afro-textured curly hair in an unstraightened natural style. Now, I took that language right from the bill, but basically we're talking about, job applicants and employees that are being discriminated against because they have dreadlocks, or they have hair weaves, or they have, rolls or things of that nature. But anybody that has an interesting hair feature, whether it be, we had an employee for a number of years that had pink hair, you can't discriminate against them. And so now we have this new act called SB 188. It was passed almost unanimously in the state Senate and was signed by the governor. So the Crown Act provides further guidance regarding hairstyles, and basically it's a new law that has an effect. Employers may implement policies that highlight acceptable grooming, but you can't draft a policy in your handbook or a grooming policy that basically outlaws or says you can't have certain type of hair, even if they have a customer or client or public interaction. So grooming and appearance policies should be driven by a legitimate business need, not subjective personal preferences. It should state the reasons for those standards and be equally and fairly implemented, should not be disproportionately impact employees in any kind of protected class. So one of the protected class are people over 40, which I am. So you can't discriminate me because I'm bald. But, you know, we have a lot of machine shops, and this could affect people with long hair that work on machines. It could be an effect to them if their hair got stuck in a machine, but that would be a legitimate business need. And you might have a requirement in your handbook that says, if your hair is longer than X number of inches, you need to have it in a ponytail when you're working certain machines or something of that nature. But basically, you want to make sure that you're not discriminating because of a protected class. And then at the bottom, I've talked about employees' religious beliefs. So if somebody is having to wear, if they're Jewish and they're Orthodox and observant, and they're wearing a kippah, or they're wearing any other kind of a religious symbol that they're required to, you can't discriminate them against that either. So I wanted to put that in there. So next are some updated revisions of required notices and brochures. When you hire a new employee, and then we recommend that every single year you have all your employees get new brochures and announcements and have them sign off that they have it. But there's a new California State Disability Insurance notice. I already talked about the new Parent Leave Act, which replaces two other notices. All new employees should receive both of these. The NPLA brochure provides employees to take leave for baby bonding, which we already talked about. So not only is there a poster, but there's also a brochure. So historically, there's been 9 to 11 notices and brochures that you have to give new employees when you hire them. Most of them are federal or state law. A few of them have to do with the Affordable Care Act. So the important thing here to notice is that whenever those notices change, you need to get the updated notices. Normally, we will send out email blasts to all of our clients, letting them know there's a new notice with the notice number, so you can download it yourself. We have a number of clients that ask us to provide the notices for them, and we do that for a small fee. The other new option, which is available for state disability and pregnancy disability leave, is that employees can be paid by check or now debit card. So they can get a debit card to use rather than waiting for a check to come in or what have you. The other thing I wanted to mention, since I have SDI up here, is that if you're an employer and you have short-term disability, I just ran across this twice, one with a 300-person company that has short-term disability, which pays 60% of income up to a certain dollar amount, in this case, $6,000 a month, but it integrates with short-term state disability. State disability changed a year or so ago, and now employees get 60 to 70% of their income in state disability, and it's limited to a certain dollar amount. I want to say it's $1,386 if my memory serves me correctly. And that state disability, you can get paid based on your income level, 60% or 70% of your income. But 70% are for lower income individuals, people that are minimum wage and a little bit higher. 60% are for more higher income people. But that means that short-term disability insurance that you buy from a carrier, such as Guardian, MetLife, Unum, what have you, that you might be buying something that isn't providing a real benefit. And so that's something to look into. So we just saw a company, actually maybe a month ago, but has 300 and some employees, and their current health insurance broker never mentioned it, but they may not need this anymore, or they may not offer them a benefit, and they're paying $12,000 a year for short-term disability. So I thought I'd bring that up now just to let you know that. Ninth Circuit, another ruling called the de minimis doctrine ruling. This just happened really recently. When I put this webinar together and this slide deck together 2 weeks ago, I did not have this slide in there, but there has been a ruling in a court case called Troster versus Starbucks. Starbucks historically had people clock out, and then if they were the last ones in and to lock up at night, they had to go through this like 5-step procedure to lock up the Starbucks store, exit the store, and lock it up. It took under 5 minutes. But an employee, Troster, sued and said, hey, I clocked out, but you're having me do this work and I should be paid for it. And they won. And that changed how Starbucks does things regarding clocking out. On the federal level, there's always been something known as a de minimis doctrine, which basically meant that if you clock out and you have to do something that might take, 1 minute or 30 seconds or 2 minutes or whatever, and it's not major, that you don't have to get paid for that. In California, the Starbucks case changed that. And in the Ninth Circuit, they just had a ruling in the Rodriguez versus Nike Retail Services case where they upheld the de minimis ruling not being let's say not being active in California, but only in all the other states. So in the Nike situation, the Nike retail stores, so if you went into one of the malls or an outlet mall and you bought a Nike, pair of tennis shoes or running shoes or what have you, when the people locked up at the end of the day, there was a 30-second procedure, and it was basically 10 to 30 seconds. And Rodriguez sued, and they won, or they didn't win. I don't remember the exact case, but it ended up going to the Ninth Circuit. And the Ninth Circuit says, no, even if it's 30 seconds in California, you have to be paid. So the question becomes, what does that mean for employers in California? And this just came up actually this morning. One of our clients called, who is in Laverne, California. They have about 38 employees, and they have a clocking in system that's done by biometric screening, which means they go to a time clock and they're biometrically screened. I don't know if it's retina or whether it's fingerprint, but that's how they clock in and clock out. But the owner of the company was reading the language in the Paychex agreement, because Paychex is doing the payroll, and Paychex said that there's some language in there about a 15-minute window that, if you can be clocked in or clocked out, and you still, if you worked after you clocked out for up to 15 minutes, you'd still, you wouldn't get paid for it. And he called me and said, hey, you were in a meeting with me a few weeks ago and you said that you had to pay people for all their time. And now he's going back to Paychex and finding out what's going on. But, Paychex is a national payroll company. It's not a local payroll company just for California. And that may be in there. I was at a client yesterday with 180 full-time employees and about 200 part-timers. And we were talking with the CFO and the head of HR about clocking in, clocking out, and how people do that and when they do it. What a lot of employment attorneys will tell you right now is that, just give everybody an extra 5 minutes of pay and don't worry about it, or 10 minutes of pay, and then you just don't have to worry about it. Other people are using a time clock or a computer clock out at the exit door, which factories and warehouses are using. But what I learned yesterday is that certain payroll services now have the ability to clock in and clock out using your cell phone. And basically, if you have the app on your phone, when you walk into the company, it immediately clocks you in, and you walk out for lunch or at the end of the day, it clocks you out. I haven't researched it yet. I just learned about it yesterday, but that might be a way of getting away from this issue of de minimis. Now, I have a feeling this will end up going to the Supreme Court of the United States, but right now, be aware of it so you don't get caught. And there are lawyers out there looking to develop PAGA lawsuits. And as we talk about this, I want to go back up to this slide for a second, is that there is a paycheck paga lawsuit in the San Fernando Valley right now. An employer is being sued for $1,250,000 because the employee is suing because there's something that's missing off their paycheck stub. So there's 9 or 11 items that have to be on your paycheck stub. Depends how you count them. I count 11, but sometimes they lump a couple together. And one of it is the last 4 digits of your Social Security number. If the last 4 digits are not on your pay stub, you could be sued. If your company, like for example, Jorgensen HR is the corporate name is Jorgensen HR. If it was Jorgensen HR, comma, Inc. period, and on the pay stub it did not say comma Inc. period, you could be sued for that because you don't have the legal name on the pay stub. And there are lawyers that are looking for those kinds of cases. The employees that they find to sue are suing under the Private Attorney General's Act called PAGA, and they are pursuing those cases. The paycheck case involved a payroll company. It's one of the largest 2, which would be either ADP or Paychex. I don't know which one because the attorney would not disclose which one, but they're working on the case on behalf of the employer. And the last 4 digits are missing. And the employer went back to the payroll company and say, hey, why don't you have this on there? And the payroll company is saying, well, you hold us and you've indemnified us for many mistakes we might make, so you're on the hook and we're not going to, come through on this. So that's kind of an issue right now, but just be aware that your paychecks stubs have to have items on it also. So moving on to whistleblower. And here's another case in California that, you kind of start to cross your, you start to look at yourself and go, what is going on in California? In Ross versus the County of Riverside, it now says that before an employee is not required to expressly state, actually this is the new court case, the employee is not required to state what the unlawful activity was if they're whistleblowing on somebody. Somebody put up here, let me just check this. There is an issue with the phone clock in out service. Employees are in parking lot or down the block and they're clocking in and out. Well, thank you. Martin Moreno just said that. So I'm going to be looking into that and it may not be something that works. So let me just move to this case. Basically, if the employee has a reasonable belief, there's a typo there, it should say belief, not believe, that a law was violated, and they're going to their supervisors or HR and they're whistleblowing, they're protected under California law, whether or not they really know whether the law was broken or not. So employers are prohibited from retaliating against that employee for disclosing information to a government agency. The next item is the one I was really kind of zeroing in on, had to do with medical testing. So again, same case, Ross versus County of Riverside. The California Court of Appeals ruled the following. An employee could bring a disability claim for a potential physical disability, even if they didn't know they had one at the time. But if they have a symptom of a disease or a disorder and they're going to get tested, medical testing, that the court has ruled that a plaintiff has a temporary, let me explain the case this way. Rodriguez had to go for some medical testing. Ross had to go for some medical testing and took off work. And the employer, County of Riverside, had a absent policy in their handbook. And Ross was handling many more absences than permitted. And they were written up because they had more absences, and they were put on probation because they didn't follow the company policy regarding absences. And Ross was getting tested for some medical issues, and he didn't know, or she didn't know, what it was. But these medical issues turned out to be a disability. And so now Ross has a disability. And Ross sued because they were put on probation and they were punished because of their absentee. I don't know the details of the case except to say that the California Court of Appeals have ruled in the favor of the employee. So that means now if somebody's taking off work and they don't have a disability and they have no physical impairment to work, but they're absent to go to the doctor for testing, that you may be on the hook if you've punished them in some way, shape, or form. It's really a slippery slope. I don't know how you can know ahead of time that somebody has an issue under HIPAA. Privacy rules. Employers are not supposed to know anything about medical conditions unless the employee brings it up, and there's got to be a reasonable accommodation because of a medical issue. But here's a case where somebody is claiming that they had a disability now, which they were getting tested for, and the California Court of Appeals ruled. I have a belief that if this will go to the Supreme Court of the U.S., and we'll have to see what happens. But just another example of employers getting caught when they didn't think they had anything to worry about in California. Cost of slip-resistant shoes. As I mentioned, we have a lot of restaurants that we work with, and I have a client that sells safety supplies to thousands of restaurants and thousands of supermarkets around the whole country. But in Townley versus BJ's restaurants, the BJ's required employees to wear black slip-resistant closed-toed shoes, but did not reimburse the employee for the cost. So employers under the labor code have to be, employers bear the cost for uniforms and anything the employee wears that is could be a shirt, could be pants, could be with a logo on it. The California Court of Appeals found that slip-resistant shoes do not qualify as a uniform because they don't have a specific brand, style, or design. So the California Court of Appeals in the previous two cases we talked about ruled in favor of the employee, but here they basically said that if the employer says you have to have, slip-resistant shoes that are black and closed-toed, that the employee can pay for it. On the other hand, if you require them to buy the shoes from a specific company, and I'll give you an example, Shoes for Cruise. It is a company that sells slip-resistant shoes and other shoes for employees of large chains and what have you. But if the employer said, you have to go to the Shoes for Cruise website and buy one of their shoes, that would end up being a problem here, as far as we can tell. I did talk to two labor attorneys about that, and they basically said, yeah, I think that might be a problem. But again, hasn't been tested in court, so we'll have to wait and see what happens. Coming to the end of this webinar, but here is discretionary bonuses and overtime. So there's been a ruling now by the Department of Labor in a letter that basically says that non-discretionary bonuses that employees receive from an employer, that you have to include not just their salary in the computation of the bonus, but also overtime. So the Department of Labor said employers must recalculate the regular rate of each work week in the bonus period to pay any overtime compensation. So I'll just give you a quick example. Let's say at the end of every quarter, you pay your employees bonuses based on how many hours they worked at their pay rate. But in a quarter, and maybe they worked 40 hours a week for 12 weeks, but in a couple of weeks they had overtime. That overtime has to be included at that pay rate. So if they're getting paid, and I'm just going to use this as an example, California, it's minimum wage is $12 an hour. LA, it's a little bit different, but let's say it's $12 an hour and overtime becomes $18 an hour. You would have to include the $18 an hour as part of the computation for that bonus, whether it's quarterly, annually, every 6 months, monthly, what have you. You have to make sure that you're looking at the total hours. As an update, minimum wage in California doesn't change until January 1st of 2020, but Los Angeles, Malibu, Santa Monica, and what have you, it changed July 1. We have a company recently that asked us about minimum wage. They're in a city that's not Los Angeles and not Santa Monica and not Malibu, and it's east of the downtown LA. And they wanted to know if they had a special requirement for minimum wage in their city. So some cities do have a minimum wage requirement. Most cities in the Bay Area do. Most cities in LA don't, in the LA area don't, but they go by the county of LA, which is basically the same as California. But if you're not in the city of LA or Malibu or Santa Monica, but you're in Southern California, you might want to double check with the city you're in to make sure that their minimum wage is the same as California minimum wage. So this could be anything from Torrance, Gardena, San Pedro, could be anything in Diamond Bar, any cities that aren't in the city of LA. And the city of LA has a big footprint, and it also has lots of neighborhoods. So if you're in the San Fernando Valley, every city except for the city of San Fernando is part of the city of LA. Beth just said the bonus is used to calculate the overtime rate in a period, not the other way around. That's correct, Beth. If I misspoke, I'm sorry. So this is minimum wage updates. If you have any questions, you can always call us and we'll help you with that. So sexual harassment training, just to let you know that you have to provide sexual harassment training for employees and supervisors, managers, or active owners before the end of the year. 2 hours of training for supervisory employees, 1 hour of training for all other employees. Temporary and seasonal employees have to be trained within 30 days. However, the temporary and seasonal employees don't have to be trained until January of 2020. I went back yesterday and reread the law to make sure I understood it. We had a client that had a question about that. They haven't trained their supervisors or employees yet. They want to know if they were on the hook for their temporary and seasonal employees. And the answer is no, they're not until January 1st. So you can do training in groups. You can do online training. And there's a lot of different sources. Jorgensen HR, we have group training for supervisors as well as for all employees. And we have an online option also available. But be aware that we're getting close to the end of, well, we're in the middle of summer, but the fourth quarter is going to be a madhouse trying to get training done because a lot of companies are waiting into doing it the last minute. They're hoping for a reprieve in the law because they're hoping that, either they're going to do it later or they're hoping that the state assembly changes the law a little bit, but and make it retroactive. So if you were trained in 2018, that was acceptable. We don't know if that's going to happen or not. So the bottom line is you should do it as quickly as possible. We think there's going to be a log jam in the fourth quarter for sexual harassment training, especially for group training, where we go out and do training in person, interactive with employees. Also, I believe that the online training is going to be inundated also, and that may be a problem. In addition to that, prices may be changing in the fourth quarter because of the demand. So the sooner you get the training done, the better. There's one other thing I wanted to add about this, but I know what it was. Okay, so if you're a law firm, Jorgensen HR now has a continuing education credit available to law firms for supervisory training, group training. We went to the State Bar of California based on one of our clients' requests, and we got 2-hour supervisory training. Most lawyers do supervise people. They have people that work for them, so it's better to get the supervisory training. So we have CE credit for that. Beth is asking a question. What is the definition of temporary EEs, and does this apply to workers from temporary staffing? So the answer to your question is, if you get a temporary employee from a staffing agency, the staffing agency is the one required to provide the training. I just met with the owner of Pride Staff, which is a national staffing agency, and I met with the gentleman that owns Ventura County Pride Staff, and I confirmed with him. But if you get temporary staffing from Robert Half or Pride Staff or Volt or any of the Aerotech or any of the staffing companies, they are required to do that staffing. Temporary might be where, because of summer vacation, you hire someone to cover some shifts, or you have a special project and you're going to hire people temporarily. Seasonal would be based on the seasonality of your business. And I'll use an example. We have a client in Santa Monica that's in the film editing business for television. And, you know, for the start of the season, they get really busy over the summer and they hire a lot of new people or returning people, but they hire people on a seasonal basis to do editing and do the work they have to get done to be able to have the work done on time for the television industry. Those people historically were independent contractors, by the way. Now they are seasonal employees, but they do have to get trained, but not until after January 1st. So that's my update on sexual harassment training. Lastly, if anybody has any questions, feel free to type them in. For mobile device clocking in and out, you can set up acceptable IP addresses to limit the location of the time card punches. So I want to thank Jane for that information because Martine had said that sometimes if you're in the parking lot, it'll clock you in or what have you. So that's something to just be aware of. So if you're looking at a mobile device clocking, you want to make sure that you've protected yourself and that you are keeping things tight as possible. Does anybody have any other questions? Seeing nobody typing, then I want to thank everyone for being on board today. We have 28 people on the webinar today. Within a week, you'll get an email with a link to our YouTube channel. And also, we will send you a PowerPoint PDF of all these slides. If you ever have any questions regarding labor law, HR, what have you, you can always call Jorgensen HR at our number 661-600-2070. We'll be happy to help you. A lot of questions, you know, you don't have to go to a labor attorney at $300 or $400 an hour. Sometimes some simple things could be answered without doing that. And then other items you need to go to an employment attorney, and we'll always let you know if you should do that. So thanks again for attending the webinar. Look in your email in the next week for the YouTube link. You look in your spam because it's going to go out to a lot of people. Thanks a lot and have a great day.